Counts for Ms. Cosma. Would you like to reserve any time for rebuttal?
Yes, sir. I would like to reserve 5 minutes, please.
Please go ahead.
May it please the court, counsel. My name is Jacqueline McMicah, and I'm here on behalf of the appellant, Kathleen Cosma. As the court is aware, this is another residential foreclosure case that has had a fairly sordid past. It has the third of attempt at a foreclosure. The case below suffers from several issues that we have raised in our initial brief. The first issue being whether or not the appellee, plaintiff below, committed a prior breach of the loan agreement, thereby relieving the performance of Ms. Cosma. The second issue is whether or not the plaintiff proved that it had the right to enforce the loan documents. And then the third issue is whether or not the plaintiff proved damages. Essentially, all three issues hit the three elements of a foreclosure action or a basic contract action: enforcement, conditions precedent, and damages. With regard to the first issue, the record reveals that the loan originated in December of 2006 with a non-party entity, Homecomings. At some point thereafter, the loan was transferred, as was and is customary in the secondary mortgage market. This was a loan that was identified at origination as a home equity loan.
Are you arguing right now that it's not negotiable? Because I think there is an issue.
No, sir. I'm advising the court of the contents of the evidence below, just in broad terms. This was not a primary first lien, is my point. This was not a home equity line of credit. It's unclear from the record below exactly what it was in terms of the disbursement schedule. And that's one of the arguments we have. With regard to the court's question, the issue of negotiability, sir, when you look at the note itself, it appears to be a negative amortization note. Those are not considered to be non-negotiable instruments under Florida law.
No, by the way, I wasn't asking a question. I just was wondering which argument that you have raised on appeal that you were addressing by bringing up the point about it being.
Sorry, sir. My law school training coming back to me. Remote as it is. Moving on. So with regard to the loan origination, at the origination of the loan, the evidence below shows that there was an escrow waiver that was part of the original deal between the original lender and Ms. Cosma. That means that Ms. Cosma would pay her monthly escrow to the various third parties instead of having it impounded by the.
So the escrow waiver issue, assuming that there was a breach, opposing counsel has raised a couple issues about that. One is that, well, just generally speaking, it doesn't excuse in performance entirely from Ms. Cosma. And I was wondering if you could address that since you're talking about the escrow waiver issue.
Absolutely, sir.
And while you're addressing that, I have a question that kind of piggybacks that, which is there was a modification that happened about 6 months after that. So if in fact there is a prior breach, why would not that modification and her entering into it, even though she subsequently stopped paying on the modification, why wouldn't that obviate any argument you have on that issue?
If I understand the court's, Judge Stargold's question, and I want to make sure I do understand it, the court is asking whether or not the modification would be a novation in the sense that it would have removed the effectiveness of the escrow waiver at the time that the modification was entered into?
Well, if you're going to argue there was a prior breach, I didn't see anything that showed that she made that argument at the time, but in essence, 6 months later, entered a modification and paid on that for a while and then stopped. Why would that not be a waiver of any argument that she had regarding the prior breach?
Understood, sir. With regard to the modification document, the court has thrown me a curveball. I was not anticipating that, and I should have. I apologize.
It's okay. Just take a deep breath, think about the answer, and you can answer. That's okay.
With regard to the modification, sir, when the court looks to the, excuse me, choose my words carefully here. With regard to the modification, I do not believe that that was before the court below, in the sense that it was pled, proven at trial. But I would like to come back to the court's question there, if I could, in a second, because I, as I said, was not anticipating it, and I should have. Yes, Your Honor, I would stand by my last answer. With regard to a waiver, sir, I believe the waivers have to be, they have to be open and obvious and voluntary. Usually that would be represented by a written document or conduct. With regard to the timing of the modification, I would suggest to the court that the prior breach put Ms. Cosma in the untenable position of essentially being bent over a barrel, so to speak, or held up at gunpoint. And that also goes towards the whole concept of prior breach. This was a payment hike that doubled her mortgage payment shortly after President Bush told us the economy was crashing before the election. With regard to the prior breach, Ms. Cosma dealt with this immediately. The record reveals that. She testified to this. She has been attempted to work it out with the then entity that she was dealing with, to no avail. Successive foreclosures ensued. And then we are here at the current case below. The current case below, which was filed in 2019, May 14th, to be exact, was filed by the appellee through its alleged servicer, Mr. Cooper, who was formerly known as Nation Star Mortgage. The complaint that was the operative pleading was including a note, a mortgage, and the note had two endorsements. One was specific from the original note holder, the payee, and one was purportedly in blank. That is the endorsement with which the second issue deals. The second issue deals with whether or not the appellee has proven that it has the right to enforce the loan documents. It revolves around the agency relationship that is purported to exist by virtue of the last endorsement, which is in blank. This is the basis for the plaintiff's standing. They have claimed.
You're attacking the endorsement in blank and saying that the endorser did not have an agency relationship with whom?
Okay, so the endorser, there's several agency relationships stated in the endorsement that we are challenging. And the first agency relationship is the agency relationship between our residential funding corporation and the plaintiff.
Let me ask you this. So let me say what I understand about what endorsements are on the note. The homecoming to residential, both of those are principals, right? Homecomings was a holder, to residential funding, another holder, not an agent of a holder. Then we have residential funding to Deutsche Bank Trust Company of Americas. Residential funding, that endorsement didn't need any proof of agency. Correct me if I'm wrong. And then you have Deutsche Bank as trustee by Nation Star Mortgage LLC, as successor, servicer, and attorney to blank. Now, you may want to attack that endorsement, but the previous endorsement was to the plaintiff.
Right.
And even if we leave aside the endorsement in blank, what agency relationship needs to be established for the previous two endorsements to be valid?
With regard to the note endorsements, the first note endorsement, as the court noted, was from the original payee to Residential Funding Company, LLC. Next endorsement was from Residential Funding Company, LLC to Deutsche Bank Trust Company Americas as trustee. The words as trustee are superfluous without the identification of the trust. And
residential funding to Deutsche Bank Trust Company Americas.
Residential Funding Company, LLC to Deutsche Bank Trust Company Americas as trustee. And so with regard to whether or not the plaintiff was the transfer.
Who's the plaintiff here?
It's a trust. It's Deutsche Bank. I always have to read, sir. I'm sorry, but because they're very.
Endorsing it to a trustee.
Deutsche Bank Trust Company Americas as trustee for residential credit loans, Inc. mortgage asset-backed pass-through certificate, series 2007-C01. Without the qualifying trust, sir, there are many Deutsche Banks as trustee. Deutsche Bank Trust Companies of America as trustee.
Are you saying that the second endorsement was not to the plaintiff?
The second endorsement was to the trustee, but without the words trustee. It's to Deutsche Bank Trust Companies of America, the entity itself as an individual, because the words as trustee become as superfluous. That's 673-1101, I believe.
I was wondering if I could segue to, since time is running a little bit short, real quick, and if we were to, does this court have the ability on this this procedural process, procedural posture to consider evidence that the trial court might have considered, despite evidentiary rulings to the contrary, or that evidence that should have been admitted, even though there's not a cross appeal based on the exclusion of that evidence, that supports the judgment as far as damages goes?
The court's asking the tipsy coachman question that was raised by Appali.
Right. So in other words, if we say, well, the court should have considered X document because it was erroneously excluded, two questions. One, I think opposing counsel, correct me if I'm wrong, there may have been, she might surmise that the court did consider excluded evidence, but also could we consider excluded evidence if we could find from the face of the record that it was impermissibly excluded in order to affirm a damages award or a foreclosure, based on insufficient, what would otherwise be insufficient evidence of damages.
The court is permitted under the Tipsy Coachman doctrine to affirm for a different reason. However,
you're into your 5, and I apologize. I'll give you a little extra time because I asked you a question. So go ahead.
The evidence still has to be admissible, and I would point the court's attention to the recent case of Jackson versus Household Finance Corp. Out of the Supreme Court, which was a case from this court where the court found that although you don't have to be the maker of the records, which has been the law for as long as I've been practicing, you have to have sufficient familiarity with the entities that did make the records to authenticate them so that they're trustworthy. So we know that they are what they say they are. That was not the case in the testimony below. The representative for the bank admitted he was not familiar with the corporate entities that were the prior servicers, because remember, sir, there were 2 entities that had Aurora in their name that serviced this loan. One was Aurora Loan Services, LLC, and one was Aurora Bank, FSB. The servicer had no knowledge of those entities, their distinction between the 2, or their business practices. Mr. Blunt admitted that some of the documents he brought, Exhibit 13 to be exact, were printed by a paralegal and not kept within the normal course of business. So I agree with the court's statement, but I don't think it applies in this case because I don't think the evidence is otherwise admissible.
All right. So that's what I was about to say, to try to recapitulate what you said. You believe it's permissible for us to reconsider the evidentially ruling, but we ought not to because it wasn't admissible. We could, but we ought not to because the correct call was made by the trial court. I'm going to give you that minute. Now you're going to be eating into your 5 minutes if you'd like to, or we can reserve it.
I just want to make one point, sir.
Sure.
The abuse of discretion standard is a very high standard. To me, if the appellate had brought a cross appeal on the evidentiary issues, which they have not, I would suggest to the court that without that showing that the burden has not been met. Thank you very much, Your Honors.
Okay, I'll round up to 5 minutes for your rebuttal. Counsel for appellee.
Thank you, Your Honors. Sarah Holliday on behalf of the appellee, Deutsche Bank. I apologize for my voice. I'm battling laryngitis, so hopefully my voice holds out. To address the last point first, very quickly, on the cross appeal issue, because Deutsche Bank prevailed entirely below, wouldn't really be a cross appeal. It would be an argument in the briefing as to under Tipsy Coachman and whatnot, whether the excluded documents should be considered or not. It is our position that the excluded documents, including the screenshots that would have showed damages calculations and the interest rate calculations, as well as some other damages models, should have been admitted by the court because they were actually business records of the servicer, albeit printouts of data. And the issue below seemed to be that they were printouts for trial, but the underlying data depicted in those documents doesn't change just because it was a screenshot. On the judgment figures or damages spreadsheets, that is also information that Mr. Blunt testified came directly from NationStar Systems. It's verified for accuracy. It wasn't changed by a paralegal. And there are summaries attached to it of the escrow advances supporting those judgment figures. So we think that those were improperly excluded by the court. But even if they weren't, improperly excluded, there is still sufficient evidence in the record to support damages in this case, albeit there's a little bit of a discrepancy between the admitted documents and and what we think the court relied upon in the excluded documents. The payment history.
A little bit of a discrepancy means
yes.
That their reward was too high. So I mean, I don't know how important the little bit modifier is.
Well,
if that is an importance and what you would rely on to ascribe certain importance to the a little bit modifier.
I would say that if this court were not to consider the excluded documents, as we think that they should, to support the final judgment, then the appropriate result here would be to remand for the trial court to clarify the damages. Because on
that, real sorry to speed things up, but you know, there's been some case law in this district about second bites at the apple. Why would this be a scenario in which we should remand for further proceedings as opposed to saying you got your one bite?
Thank you, Your Honor. The distinction in the case law between remanding for a second bite, as you put it, really relates to whether there's no evidence of damages versus there's some evidence of damages. And as we stated in our answer brief on page 39, the cases support that when there is some evidence of damages, there's just an error in calculation where they need to be adjusted. That's a situation where it's appropriate for remand because there is essentially a prima facie case of damages in that case, and there just needs to be some clarification.
Doesn't matter if this is a foreclosure action. In other words, what's really being sought here is to foreclose on property, and
I think that is also a weighing factor, Your Honor, because it's not a monetary judgment. Now there is, I would concede that there is a redemption. It would affect the amount that the borrower would have to pay to redeem if they could in fact redeem. So there is that implication there. But yes, I would say that there is a difference here because it is not a monetary judgment in and of itself.
Ms. Holliday, if you would, I would like to clarify my understanding of the discrepancy. What I think your argument is that the documents that were excluded resolve the discrepancy. Is that correct?
That's correct, Your Honor. Yes.
Thank you.
They in fact provide the exact amounts that are in the judgment figures. If you don't have those and you just calculate based on the documents that were admitted into evidence, I think there's about a $17,000 difference in taxes and about a $2,800 difference in insurance, just by way of example. And as far as, so on the second issue on the failure of standing.
Well, could you go back real quick and just walk us through why the evidentiary ruling was wrong on the excluded evidence? There's the screenshots, and then forgive me if I forget the term of the payment history of what it cost the bank for the insurance, et cetera.
Correct. So
you did. Could you just, I mean, that's the only way that we're not going to reverse, right? I mean, let's be frank, in your briefs, you even kind of acknowledge that.
Right. Or remand for the proceedings. Yes, Your Honor. So the screenshots themselves, let me address those first. There was ample evidence and testimony by Mr. Blunt as to the data that were contained in those screenshots, and that data, so what these were screenshots from NationStar's LSAN system, which is their servicing platform where all the information related to servicing is placed, and where the data concerning payments, escrow, interest rate calculations, and other advances is kept and maintained. In order to have documentary evidence at trial, you can't really bring the system in to court, which is what opposing counsel below argued. You know, the data system isn't here in court. Well, in order to bring the system into court, you have to have some type of printout. You have to run a report, or you have to do a screenshot, and the screenshots are what what NationStar did to show the data that was in the system. And the witness testified pretty comprehensively as to how that data is input, how on onboarding, even for the prior servicers data, it's validated, and the screenshots themselves related to NationStar's specific servicing of the loan, and how all of that related. So we think it was improper because he laid the proper business records foundation. The issue below that the court seemed hung up on was that it was a screenshot. It was a picture of a screen from a data system that wasn't in court. Well, that's not the requirement. If that was the requirement, you'd have to bring in servers and computer systems for the court to look at the data system live, and that's just cumbersome. As to the damages spreadsheet or judgment figures, as they're often called, it's a similar concept. It was information being pulled from the LSAM system that was then being generated into a report. The fact that it was done by a paralegal in order to demonstrate the information that's in the system for purposes of proving it up at trial, it's a distinction without a difference. The data itself is the business record of NationStar about which Mr. Blunt testified pretty comprehensively. And so the fact that there is a report that has to be generated somehow from that system to then present to the court doesn't exclude it from the business records. In fact, it is a business record because it was created from the data that is the business ongoing business platform of the servicer. So for those reasons, we think that the exclusion of those was improper. They should have been properly admitted as business records. Moving on to standing, if there are no other questions on damages. The arguments on standing that were raised on the appeal are slightly different than what were argued below. But regardless, we think that they're easily dispensed with. The borrower doesn't have the authority to challenge the endorsements on the note. Under 670, Florida Statute 673-308 sub 1, unless the borrower introduces some evidence that the signature, the endorsement is forged or otherwise unauthorized, the plaintiff, in this case Deutsche Bank, is not required to affirmatively prove it's valid. We're entitled to a presumption of authenticity and authorization. Here, there was no counter evidence. There was just speculation based on a limited power of attorney. What's interesting about the limited power of attorney is that it was dated November 19th of 2015. The endorsements that are on the note were filed in a 2016 case and then in a 2019 case. So the limited power of attorney predates both of the filing of those cases, which proves when the endorsements were placed on the note. So the only evidence before the court on the authority issue shows that, at least from the court's perspective, and even taking into consider the Ortiz presumption, which is you look to what endorsements were on the note at the time of the complaint. Here you can look to both the 2016 case, where the note was located when the complaint was filed, in the 2019 case, as well as in the 2019 case after the original documents were retrieved from the court. Because they were with the court, Deutsche Bank is still considered to be in constructive possession of them under case law that has been clarified over recent years, because they were the entity that placed the original note with the court, and they're the entity that retrieved it. So for those reasons and the other reasons stated in the briefing, we think that the standing argument also fails. On the failure to provide notice concerning the escrow waiver or rescission of the escrow waiver, as we briefed in our answer brief, that issue was not really the focus below, and we don't agree that it was tried by consent. In the reply brief, Ms. Cosma makes the argument that there was a single interrogatory response that seemingly raised this issue, although that wasn't before the trial court at trial, and that there was a supposed failure to contemporaneously object to the waiver issues as they came up. I would point out that in the record, when the unsigned escrow waiver was attempted to be entered into evidence, there was a contemporaneous objection by trial counsel at that time, and then there were further objections in closing. As the escrow issues concerning whether Ms. Cosma paid them or not related both to indebtedness, an issue in the case, as well as potential default, the failure to contemporaneously object, even if that was the case, does not indicate that the issue was tried by consent. And
I have a
that's
question for you about
Sure.
modification after the purported breach. Is there any sort of provision in the modification agreement or document that would support a ratification argument or some other similar position?
So unfortunately, the loan modification document itself was not in evidence at trial. However, Ms. Cosma admitted that she did make these modification payments even after knowing about the escrow issue. She also admitted that she never raised the escrow issue with NationStar, the servicer who brought the current action. So for a confluence, the circumstances here, we think would support a waiver under contract principles. And specifically, one of the cases cited in the initial brief by Ms. Cosma, the Hamilton case out of the Southern District of Florida, has a quotation that says, when a contract is not fully performed on either side, is continued in spite of a known excuse, the right to rely on the known excuse is waived. In turn, the defense based on the excuse is lost, and the party who would otherwise be excused is liable if he or she subsequently fails to perform. And that's what we have here. Ms. Cosma knew about the escrow issue, or supposed escrow issue, as opposing counsel stated in her argument earlier. Ms. Cosma raised that issue, yet she still then entered into a loan modification agreement and paid on the loan, which is in of itself ratification of the loan, then failed to raise that issue again at any other time, including with the current servicer. So under the reasoning of Hamilton and general waiver of contract principles, there would be a waiver of that prior breach argument. In addition, there are numerous other reasons why the prior breach argument fails. Number one, this is the escrow covenants in the mortgage itself are a independent covenant. They're not dependent on the original agreement. The mortgage itself, the main agreement is I give you money in exchange for a security interest in the property that occurred. The escrow issues admittedly, and I think this was acknowledged in the initial brief in this action, they occur at a later time, especially if there was in fact an escrow waiver. The escrow issues would arrive at a different time, which means that they're an independent covenant. And therefore, even if there was a breach of that independent covenant, it is not a basis for Ms. Cosma to completely avoid her performance under the agreement. The result, as she concedes in the initial brief, would just be that the servicer could not collect escrow from her. And then I would also note, as it relates to the notice issue or the failure to give notice, I don't think even on the merits and on the record before this court, the borrower satisfied her burden to prove that affirmative defense, which is in fact her burden. There was no signed waiver of escrow that was entered into evidence here. There was just an unsigned document and self-serving testimony that it must have been signed because it was in the closing documents. It's not necessarily true. There was also no evidence of any payment of taxes, insurance, other than general statements of the expert witness who said, I recall seeing it, and then Ms. Cosma herself saying she did pay it. So there's a complete failure of proof on the affirmative defense regardless. And if there are no other questions, for the reasons stated in our brief and argued here, we would ask that this court affirm the lower court's final judgment, or in the alternative, if this court feels that there was an issue with the damages calculations because this court is not willing to consider the excluded documents, which we think it should, remand for clarification proceedings as to the damages amounts as permitted by this district court case law.
Thank you. Counselor Ms. Cosma, you have 5 minutes for rebuttal.
I think that's the hardest thing for me. May it please the court, now that I am unmuted. Your Honor, with regard to the amendment issue, this court in the JAK Capital LLC versus Adams case last year recently said that where there's no objection to the introduction of evidence on that issue, then the trial by consent argument is not well taken. In this case, the appellee did not file a pretrial motion in limine, despite the fact it was on notice because of the interrogatory answers that this escrow waiver was an issue. The appellee didn't object when it first came in front of the trial court. They cannot claim unfair prejudice because they were advised 47 plus days before trial of the escrow issue, and they therefore had a fair opportunity to defend. The issue with regard to whether or not the appellant waives this argument by not pleading it is easily answered by 1.190B, and we have cited the relevant cases and the citations to the record to the court in our reply brief. The problem is the evidence was in, and then the objections were made after the fact. The discussion about the escrow waiver occurred during the voir dire, I believe, or cross-examination of the corporate representative. It was not raised then. That would have been the appropriate time, if not during pretrial motion. The issue with regard to standing, although it is an affirmative defense, it's the first element in the plaintiff's case in chief. And with regard to the various ways one can prove standing, the plaintiff appellee has chosen to be a holder. With regard to being a holder, we have to look at the relationships between the various entities that actually have the note in their possession, physical possession. So when we look at those things, as we raise in our answer brief, we have to look at whether they exist at the time that these transfers were occurring. And we suggest to the court that they did not. And I've laid out the timeline in my reply brief. I keep saying answer, I mean reply, I apologize. So I'm not going to belabor the point. But for the reasons we have identified in our filings, and the fact that there's no evidence of the first and third elements of the appellee plaintiff's case, we would ask the court reverse the remand with orders to dismiss. Thank you. Thank you, counsel.
Thank you both. That concludes the argument for this case. You will need to click the red button that has the word leave on it on your Zoom screen, and you can keep watching online, I'm told, and then I will call the next case. Thank you both.